Good evening. My name is Indu and I'm with the Internet Freedom Foundation. We're very happy to see all of you here for Privacy Supreme 2025. As you will all know, this is IFF's flagship event in its fifth edition, marking the KS Puttaswamy versus Union of India judgment of the Supreme Court, which reaffirmed the right to privacy as a fundamental right under the Indian Constitution. In each edition of Privacy Supreme, we not only discuss the legal landscape surrounding digital freedoms, but we also engage in the broader conversation of digital rights and how it ought to be practiced, given that technology and the internet define how we engage with the state as citizens. And with that, let's jump right in. I would like to call upon IFF's founder, Director Apar Gupta, to introduce the theme for this year's Privacy Supreme and invite the keynote speaker for this event.
Thank you everyone for turning up today to celebrate Privacy Supreme, a celebration in which there is reflection, there's also engagement with a broader cultural conversation, and we hope that through the keynote speech by Justice Patel, but also through a panel which follows and engages with how Indian science fiction looks at the question of privacy beyond it being something related to surveillance, broader questions of power which are there in joint families, in caste exclusions, in welfare systems, and exclusions from day-to-day lives from the rights and entitlements of the Indian Constitution. This conversation can be deepened. We are really glad that we have chosen a theme in which we look at not only the past and the present, but also look to the future, and this picks up from the X-Men movie. It's, by the way, it's rated very highly on Rotten Tomatoes. We chose it because it's genuinely a good movie. It's called Days of Future Past. It has a stellar cast. I would recommend everyone to go back and watch it. And so taking a cue from that, we have also made certain small things around this event which add a thoughtful touch. We hope it's thoughtful and that prompts a thought in you. For instance, there's a Jenga game right beside the door, and we have taken key historical moments which interact with the right to privacy. It may be a court case, it may be an act of legislation, it may be a disclosure in a popular newspaper such as Pegasus. The date is written, the event is written, and it's in a Jenga-style game. So we ask you not to collapse that tower, but to replace it piece by piece. And you can take a small block from it as a memento, we hope a memento or a paperweight, and you can write a date and you can imagine the past and the present, or maybe even the future. We'll be keeping that in our office and we hope you engage with it. And today's program will run till 9 p.m. and Justice Patel's speech will be for about an hour, after which there'll be a 15-minute intermission, and after that there will be the panel. Right before the panel, you may also notice there are some packets here. In that packet, there's a small zine in which there are there's one original story and message by Manjula Padmanabhan, and there's a extract also from Indra Pramit Das from one of his previously published stories. And possibly you can also engage with that. It has some stickers, it has a postcard which has been designed by Dhananjay Kalra. I think he's somewhere here. He's at the back, and he's done most of the designing around the event. Okay, so without further ado, I would like to call Justice Patel. Should we look at the past, present, or the future of privacy in India? Justice Patel, the floor is yours.
And fair warning, this is going to take a while. As I recounted a few months ago at a lecture in Pune, from which I have freely borrowed for part of this evening's address, and in a context I shall not bore you with, I once found myself at the Foreigners Regional Registration Office behind St. Xavier's College in Mumbai. The officer there very kindly asked if I might be interested in some special branch archival records. I said yes. He took me up 2 floors to a chamber where there were rows and rows of these leather-bound volumes. He showed me some of them. It was astonishing. I had no idea that records like this even existed. They went back to 1915 or even earlier, and they were a minutely detailed record in an age of no cameras, no internet, no hyperlinking, of what we today called surveillance. Individual people in plain clothes, were asked to keep watch. There is a narrative about a sinister Parsi gentleman who was found loitering around the docks, and the message recorded was to apprehend him when he disembarked from his steamer at Aden. The detailing is incredible. In one instance, there is even a dinner menu. What's missing is equally intriguing. The pages from Gandhi's journey to Ahmedabad just before independence, which I believe is now at the British Library in London. With surveillance, there's the why and there's the what. Let's take a quick look at the what. The word surveillance is from Middle French, traceable to Latin roots, vigilare, to keep watch. In French, sur or over, and veiller or watch, together overwatch. In our contemporary understanding, it is close observation of an individual or group, today whether or not of a person of interest, that is to say under suspicion, and in espionage, a systematic method of constantly observing and recording events, persons and places by manual or electronic means. That's the what. The why is far more difficult to understand, at least because surveillance, at least, or whatever word you want to use, is indeed very ancient. I would venture to suggest that if one reads old texts for their subtexts, one should expect to find mention of what is nothing but surveillance going back in time several millennia, indeed several centuries before the Common Era. Surveillance in some form seems to me to always have been an adjunct of organized civil society, most especially as a feature of urban living from the oldest times. The reason is that unlike the more thinly populated and more dispersed agrarian settlements, urban life demanded almost from the beginning a maintenance of what people love to call law and order. There is, of course, an undeniable argument to be made of the necessity of maintaining law and order in intricately woven societal settlements. The absence of law and order would be urban chaos and anarchy, and the term encompasses everything from rules of the road and parking to vending, passing by, cleanliness, hygiene, and so forth. But where lies the boundary? At what point can one legitimately say the need for overwatch ends? At one's doorstep? Where or what is the threshold at which surveillance must stop? At what point do we say, so far and no further? The answer to this question has always been infinitely problematic, and the problem comes from two different directions. First, the choices or the lack of choices that are thrust upon us, which I will call the external pressures, and second, the choices that we freely make for ourselves with such tools as we might have at hand. The two have different profiles and different intrinsic dynamics. Can you opt not to be on Facebook, X, or Instagram? Not to have a smartphone with WhatsApp? Evidently, yes, you can. Will it impact your life adversely? Oh, that's a hard call, but it's one that's still up to each person to make. But can you function effectively today without what we call ID proof? Aadhaar, a driving license, passport, a voter's ID. I dare say we should be hard put to find a single person among us here today who manages to get by with none of these. The common denominator is data, specifically data about ourselves. We all use this word and we salt almost everything with it. We also claim ownership of it. But what is this word and what does it imply? We understand data today to be a compendium of what are called values. How much, true, false, and so on. On its own, data is useless. It is just a collection of numbers. It is the interpretation of that data in ways more or less formal or structured that yields something of worth. The process of interpretation is the algorithm. Data is the plural of datum. That's a Latin word. And here's the surprising thing. In Latin, the meaning is the thing given. Mark that, please. It is the neuter past participle of dare, meaning to give. Data, datum were words first used in English 500 years ago in the 1640s, and they remained there for the next 4 centuries until the middle of the 20th century, when it was first adopted to mean storable computer information. The word data processing, again the word processing should be noted, arrived only in the mid-1950s. Data is only a value. It is not information. And information, in turn, is not knowledge. On their own, data and information are both relatively useless. Once we process that data, we begin to know certain things, patterns, habits, preferences, tendencies, likes, dislikes. And then it gets more intimate. We know about dress and food and travel and reading and entertainment. And we use this knowledge, processed information, even to define relationships and through that ourselves. Yes, think Tinder or any dating app. Let me use this to set the stage for what follows. Pause to remember the origins of the word datum, the concept of giving a thing. What is this thing and who is giving it and to whom? Why? As soon as we latch on to the concept of giving, we are forced to accept the other face of it, namely ownership or proprietorship. So there is the giving of something by someone who owns it to someone else. At a philosophical level, this throws up more problems. For instance, take an elementary chunk of data, your date of birth, expressed as a value. This becomes data as we now understand it when it is given, that is to say, when it is shared by the one to whom it attaches with someone else. When it enters a birth register, for instance. Therefore, data is the communication of a number, a symbol, or a value. Data travels to the level of information when the symbols or the values of data pass through some sort of filter. Knowledge, the next level of abstraction, builds on information and speaks to awareness of data and the information, and then injects or embellishes it with something more. Let's take an example from something all of us use every day, Google Maps. Some of you probably used it to get here. The distance by road between 2 points on a map is data. A message about the condition of the road or the traffic on it at any given time is information. A suggestion about an alternative and faster route comes from knowledge. To complete this part of it, let me just mention the next level, wisdom. That is a further refining. It gathers data, information, and available knowledge to make an ethics-based call, fundamentally on right and wrong. Wisdom is tied root and branch to governing concepts in law, justice, equity, fairness. But we would do well to remember that while repositories of data and information can be relatively anonymous, and knowledge, even with its incidence of authorship, has the merit of being widely accessible, wisdom is a quality that is extremely personal. It is shaped by disparate influences, not just data or information or knowledge. Here, politics, faith, attitudes, backgrounds, and worldviews come into play. Data, information, knowledge are all agnostic. It does not matter what job you are doing or what societal role you fulfill, they remain the same. Wisdom, on the other hand, is constantly shape-shifting. A common mistake we make, especially in this country where paying obeisance and being subservient is almost a national trait. We are constantly in search of someone whose feet we can touch, often to realize a cherished ambition, is to assume that occupying a position of authority necessarily brings wisdom with it. Our collective experience, and yes, I do mean the judiciary, should tell us that this is entirely untrue and there is no valency between the two. Abir Mukherjee is a writer I much admire. He has a series of novels set in Fairdersea, Calcutta, about a British policeman, Sam Wyndham, and his Indian assistant, Surendranath Banerjee, nicknamed Surrender Not. They are marvelous detective tales stuffed with atmosphere and context, from opium dens to stately mansions and starchy clubs, and always, always the Hooghly. All of this in the backdrop of the independence movement. In one of these books, A Necessary Evil, there is a wonderful line I'm adapting from what a female character says to Wyndham. The truth, she says, no more entails justice than high office entails wisdom. Now let us set this in the context we have derived. We have not just data, information, and knowledge, we have repositories of these, and I'm excluding wisdom because truly valuable repositories of wisdom are very hard to find. In another word, we have libraries. Let me return to the fundamentals. My argument is this, that the act of harvesting and collecting data, making information and deriving knowledge serves two primary purposes. First, societal improvement, the progression of humankind to greater and greater levels of civilization. And second, the control of one group, the overseers, over the other, the overseen. Today, the latter purpose seems to have overtaken the former. For it cannot surely be coincidence that the rise of the political right wing parallels the growth of surveillance. The processing of personal data about the individual, gathered and harvested ever more aggressively, more intrusively. Francis Bacon famously said, knowledge is power. Knowledge, mind you, not information. But the truth is that all surveillance is information, and surveillance is, above all, about some form or shape of power, that is to say, control. It is everywhere. It is not only about the enemy, whoever that might be. It is about our daily lives, how we shop, where we travel, what we read, the choices we make. I'm sure that many of you, like me, have been utterly, how shall I put it, discombobulated. Freaked out is, I think, a better word. To find that your cell phone feed suddenly starts peppering you with offers about that trip to Greece you were talking about with your family only last night. What on earth is going on? How is this even possible? What part of our lives is truly ours? The more we fill our lives with digital data, it seems, the less we have control over it. Does this not remind you of that fabled Pythagorean cup named after that great man of science and all things triangular, Pythagoras? He is said to have invented this device, a drinking cup, which, when filled beyond a certain point, had a siphoning effect, thus draining the contents through the base. It was meant to be a practical joke, but I fear the joke is on us. The more we want, the more control we cede, and the less is truly ours. I have come to detest the expression artificial intelligence because it seems to me to imply that left to ourselves, humans have nothing to commend themselves except its converse, natural stupidity, which may well be true in this era of climate change, especially when one sees the official government line on fossil fuels and carbon emissions in Chapter 13 of the recent 2023-24 Economic Survey of the Government of India. And, I dare say, even some astoundingly inexplicable decisions of the highest court negating efforts to preserve a unique species or to recognize the fundamental right to free speech. But all that is stuff for another evening. As technology advances, our adoption of it increases. It's no longer a bare bones set of numbers like a date of birth. We have now moved to the level of yielding far more intangible data about ourselves, everything from books to sexual orientation. Why do we do this? Because, and this is the other danger point, it is convenient. It makes our lives easier. We can pay others swiftly. We can send and receive messages instantly. We share images, and we are told this is important in an interconnected world. But all this convenience has a cost. And as we shall see, ceding this level of control is extremely dangerous, especially when it is unguided and unsupervised. If surveillance is oversight, we have to ask who oversees the overseer, which puts it into a certain perspective. Our view of surveillance is based on and emanates from a propagation of a culture of fear. This has become more pronounced since 9/11 and after the COVID pandemic. And the thinking is that surveillance is necessary to keep us safe from harm. But this so-called necessity immediately lends itself to all kinds of purposes, from lockdowns to film and book censorship, suppressing all expressions of dissent, and other forms critical to any functional democracy under the rule of law. So we have this tension, one of increasing relevance to us, between data about ourselves, which we allow to be harvested by others, apparently for our greater good, and our demand for enforcement of a particular human right, the right to privacy, the right to be forgotten, the right to be left alone, and the right not to yield data. If data harvesting and its uses are swept in for some greater convenience, we must acknowledge that invariably and without exception, fundamental rights and all human rights are exceedingly inconvenient to those in power. And it is for that very reason that we have Part 3 of our Constitution to protect these highly inconvenient rights. Boundaries between public and private are constantly shifting. Our lives are online. In such a world, privacy is no longer just a matter of a personal preference or a private morality. It is a matter of individual freedom versus public power. It is at its core about who we are and who we are allowed to be. In an age where information flows this swiftly across borders, screens, and between people, it is an era defined by two cardinals: the ease of connection and the abundance of data. And we are confronted with promises of unimagined benefits from this digital transformation, compelling us to ask, how much are we exposed? What remains ours alone? For all its relevance, privacy is a difficult concept to pin down. It can mean many things: the solitude of a quiet room, the confidentiality of a medical or legal consultation, the secrecy of a vote cast, or in today's day, vote not cast, or the right to browse the internet without being tracked. Why does it matter? And why should we care about it in a country like India, vibrant, plural, democratic, vastly unequal, deeply complex, exceedingly noisy? The question is not academic. It's one that recurs with maddening frequency in our courtrooms, in judgments that define the relationship between the state and citizen, and also in more colloquial dialogue. For it is also a question that matters in homes and hospitals, in marketplaces and municipalities, in apps and algorithms. There are three reasons. First, privacy matters because it is essential to freedom. Without the ability to think and speak freely, to form relationships of one's choosing, to explore beliefs and ideas without fear of scrutiny or punishment, the constitutional promise of freedom is hollow. Privacy gives freedom, depth, and meaning. Second, privacy is foundational to dignity. It is the recognition that each human being has an inviolable zone in her or his life that is hers or his alone to shape and share. Dignity means not being treated merely as a statistic. It means having control over that which is one's own. Third, privacy is a condition of democracy. In a free society, people must be able to question authority, protest injustice, organize collectively. Now, if every moment is watched, every message stored, and every disagreement profiled, dissent becomes dangerous. Surveillance chills speech. It silences the very voices democracy most needs. And finally, and above all, privacy is about power. Who has it, who exercises it, and who resists it. In the digital age, power lies not only with the state, but increasingly with corporations, platforms, and algorithms that seem to know us better than we know ourselves. The choices we make are shaped by invisible forces that track, predict, and yes, manipulate. Privacy is the right that allows us to push back. Privacy is by no means a new concern. Some have traced it back at least to 1890 when Louis Brandeis, later US Supreme Court Justice, and his then law firm partner Samuel Warren published a paper in the Harvard Law Review, The Right to Privacy. They suggested there had to be legal recourse against intrusion by outsiders into private domestic affairs. The debate went on for the next century until about 1960, when William Prosser published a study asserting that the right to privacy had grown from rights against publishing private data to far wider concern. One of these expansions is important to us. Deep fakes, or distortion of a person's image or voice or other personally identifiable data. Privacy is a shape-shifting beast, and we must make some attempt to define it if we are to assert it as a human right. Some matters are, we say, private, nobody's business except ours. But the other dimension is that some aspects must be kept clear of intrusion by any authority. In other words, there are parts of privacy where we do not yield data, where we do not cede control, where we contest the power grab. For many years now, my childhood friend Shyam Devan, a formidable lawyer from a family of formidable lawyers, has been tirelessly fighting one legal battle after the other about privacy. This is only one of many he has taken on. In Devan, we find, I think, and I confess to being hopelessly biased, so this is not very judge-like, that rare combination of advocacy of the highest order and incisive, original, and astute scholarship on a range of subjects, but all hovering around a core of constitutional protection. Delivering the 13th Durgadas Basu Endowment Lecture in 2020 on constitutional liberty and privacy, Devan opens with this delectable morsel. Digital age provides an inflection point to explore the day's theme. The Constitution and liberty are old bedfellows. When did privacy enter this company to create a ménage à trois? I mention this paper by Devan for a reason. It set the stage for what follows. I quote from an early part of it. In the internet age, we must recognize that in order to preserve our liberty in the new interconnected reality, the spaces we must protect and regain if necessary, are not the traditional spaces. Important as the integrity of our body and home was and is, preserving the ownership, control, and integrity of our data is the most crucial aspect of preserving liberty. This now means protecting ourselves not just from the state, the traditional contestant in the tournament to preserve freedom, but also private behemoths, the big technology companies who harvest and sell our data. In the 2020 lecture, Divan focused attention on that most intrusive of all data gathering measures, the UIDAI Act and Aadhaar, and the Supreme Court's 2017 nine-judge bench decision in KS Puttaswamy versus Union of India, which we remember here today. There are parallel Puttaswamy cases, but all stem from a challenge to Aadhaar. There is yet pending another dimension which need not detain us today on whether or not it was correctly decided as a money bill. The privacy judgment is crucial. Before I get to that, I should mention the 2019 five-judge decision in Puttaswamy called the Aadhaar judgment. Many things are remarkable about it, but one of the most astonishing things is squirreled away in an editorial comment in a mainstream reporter of law cases. The Supreme Court judgment, with different opinions of the judges, spans 940 printed pages. Several leading pages are summaries, what we call head notes. Buried in this is an entirely gratuitous editorial digression. It goes like this: Ed. The issue squarely faced by the court in this case goes to the dilemma at the heart of ethical philosophy, capital E, capital P. Is it possible to have social progress, a necessary condition for individual flourishing, if the Kantian postulate of never using human beings as means to ends is taken too literally and dogmatically? Even Kant himself allowed for putting the interests of the Commonwealth above those of individuals when it came to preservation of the Commonwealth, for without the Commonwealth or the state, it is simply impossible to have any meaningful civilized existence. And all that obtains is the Hobbesian hugger-mugger. Of course, the liberal challenge is always to try and absolutely minimize this use of human beings for the greater good, and which must be non-discriminatory. For instance, is secure modern life conceivable without the critical role played by the armed forces, police forces or security forces, and the secret services in every modern state? And do not the rest of us use them as a means to an end when they are sacrificed on the front lines battling for our freedom and security? Aadhaar, really? Should the Aadhaar project, which has finally given us a unique, non-duplicable identity to every one of us, 1.2 billion Indians, something considered impossible until it was actually, it goes on. I didn't make that up. I couldn't if I tried. Because conceptually and philosophically, Aadhaar is and always has been problematic. Small digression. I remember voicing an objection to it in late 2013, a few months after I was appointed a judge. I was smacked down with some derision by a senior colleague who said I had spent too much time with the Khadi Jhola crowd. That judge went on to the Supreme Court, and his judgment, one that echoes at least a bit of what I'd complained of, including that there was then no controlling statute, lends credence to one of my long-held beliefs that hindsight is usually the lack of foresight. Even today, the problems with Aadhaar are manifold. I had some experience with a precursor project when I was engaged in an arbitration regarding what was then called the Bhimasha project in Rajasthan, was the same overall objective and the same problems. But we had some incredible instances that popped up in the course of that litigation and which were replicated in the early days of the Aadhaar scheme, such as fake Aadhaar identities, including one legendary one from Hyderabad, where an Aadhaar number was issued to Palak, son of Kothmir. Privacy and the evolution of privacy law is the reason why very similar enterprises overseas have been abandoned. Aadhaar is the one deeply personal data harvest that is not siloed. No policeman can ask for your passport for a traffic offense, and no immigration officer can see your voting ID or driving license when you enter or leave the country. Aadhaar negates all of this. So when in 2017, the 9-judge bench of our Supreme Court recognized in Puttaswamy that the right to privacy is a fundamental right, it did not merely affirm or discover or unveil a legal principle. It voiced a truth far deeper, one that we are, I think, only now beginning to comprehend, that privacy is the bedrock of individual freedoms. The road to Puttaswamy was long and uneven. For decades, Indian jurisprudence treated privacy as entirely peripheral, sometimes recognized, often avoided, rarely understood in full. Earlier cases, as we shall see, offered glimpses of recognition, but without coherence or conviction. It took time and a changing world for the judiciary to fully see privacy for what it is, not a Western import, not an elite indulgence, but a constitutional necessity. But even after this recognition, privacy remains contested. It raises hard questions. Can a government compel biometric identification? Is data protection a public or a private matter? Can individual rights be overridden for the collective good? These are not easy questions, nor are they merely legal. They are moral, technological, political, and profoundly human. And they lie at the crossroads of governance and ethics, of citizenship and consent. In India, these questions are especially important because of our scale and diversity. When we are building one of the most ambitious digital infrastructures in the world, linking citizens to services through various digital platforms, we are, with this connectivity, encountering the risk of profiling, exclusion, leakage, and abuse. Perhaps more importantly, in a country as bisected by economic inequality as ours, we have to ask, how do we protect privacy not just for the privileged, but also for the poor? How do we ensure that digital transformation does not come at the cost of constitutional values? Our answers should begin with a clear understanding of a tracing of judicial history, and I will go through this relatively quickly. My attempt is to chart that journey, to look, as it were, to the days of future past, and to trace the contours of privacy in Indian law from the early years of constitutional silence to the hesitant recognition of the 70s and 80s, and finally, the digital dilemmas of the 21st century. Why is this necessary? I think it behooves us now to do whatever is necessary to build what I will call a culture of privacy. One in which rights are respected not just by law, but by design. Something that we have not so far done, or at any rate not done well enough. This is a vision of a culture where citizens are informed, empowered, have their individuality respected, and not just in the arcane language of court halls, but out there on the streets. As we know, the Constitution of India does not contain the word privacy, at least as it was originally enacted. That was not accidental. Privacy at that time was not part of a larger global vocabulary. We did have strong personal guarantees of personal liberty under Article 21 and the freedoms in Article 19, but in the early years, these guarantees were often interpreted narrowly, especially when they came into conflict with the interests of the state. In 1954, a newly minted Supreme Court of 8 judges had before it the case of MP Sharma versus Satish Chandra about the right against self-incrimination and powers of search and seizure. The petitioners were demanding that documents seized during an investigation be returned to them. All 8 judges sat to hear the case, and the court held that without a provision like the American Fourth Amendment, privacy could not be read into the fundamental rights in Part 3 of our Constitution. Privacy had its first test in 1963 in Khadak Singh versus the state of Uttar Pradesh. Khadak Singh was a man suspected, though not convicted, of criminal activity, and he was being subjected to continuous police surveillance, street watch, night visits, unannounced entries into his home. He challenged this on the grounds that it violated his fundamental rights under Article 19 and 21, and the Supreme Court was divided. The majority held that unauthorized intrusion into a person's home violated ordered liberty and struck down the clause allowing domiciliary visits, but it did not recognize a general right to privacy. It said famously, our Constitution does not expressly declare a right to privacy as a fundamental right. Justice Subbarao, dissenting, thought otherwise. It is true our Constitution does not expressly declare a right to privacy as a fundamental right, but the said right, he said, is an essential ingredient of personal liberty. That was prophetic, but at the time he was in a minority. Khadak Singh left privacy in a peculiar place, acknowledged in part, denied in full. But the door had cracked open just a bit. More than a decade later, in 1975, in Gobind versus State of Madhya Pradesh, the court took another small step forward. This was on similar facts, police surveillance, an argument that this violated the right to privacy. And Justice Matthew, writing for the court, acknowledged that such a right might be implicit in Articles 19 and 21. But the court did not categorically affirm a broad right to privacy, but assumed its existence and then positioned it against countervening state interests. It was cautious and, as a recognition, conditional, but it was the beginning. I may be entirely wrong in this, but my thinking is that the watershed moment before Puttaswamy, the earliest one, was in 1978 in Maneka Gandhi versus Union of India, which was about passport seizure. Let me explain why I'm saying this. She argued that the denial of a passport violated her right to travel and her right to life and liberty. What followed was a landmark judgment that redefined Article 21. It held that any procedure restricting life or liberty had to be just, fair, and reasonable, and it rejected earlier, narrower interpretations and brought Article 21 into conversation with other fundamental rights, especially Articles 14 and 19. I agree, it did not directly deal with privacy, but what it did do was to alter the framework within which the rights were understood. Personal liberty was now more expansive, not restrictive. These three articles were no longer in silos. And I believe this proved vital, for within that liberty, room was being created conceptually and constitutionally for privacy. In 1981, again in Malak Singh, the court dealt with surveillance, though this was being done without overt interference. The court upheld the practice but said that such surveillance must not be intrusive on private life unnecessarily. Of course, what is necessary intrusion is always a dilemma. The 1994 Auto Shankar case, R. Rajgopal versus State of Tamil Nadu, was about whether a magazine could publish the autobiography of a convicted serial killer, allegedly written while in jail. The court took the opportunity to articulate a right to privacy in Indian law and said that it is implicit in Article 21, but positioned this as the right to be let alone. Privacy of one's own, one's family, marriage, home matters. This was a shift in judicial thinking from ambivalence to affirmation. It recognized that there is a zone of inviolate autonomy and that intrusions into that space, especially by the press, have limits. It was something of a breakthrough. 1997, PUCL versus Union of India, the telephone tapping cases, was perhaps one of the most important cases before Puttaswamy. PUCL challenged a provision of the Indian Telegraph Act saying that it lacked adequate safeguards and allowed for arbitrary and unchecked intrusions. The judgment did not articulate a full theory of privacy, but it treated communications privacy as part of personal liberty. Now, it is here that we see the court beginning to recognize privacy as both substantive, the content of the communication, and procedural, the requirement for some form of due process. So by the early 2000s, privacy had become a regular feature of constitutional litigation. Its recognition was still uneven. Courts acknowledged privacy in some contexts, search, seizure, surveillance, but hesitated to recognize it as a full-fledged right. The advances were incremental. There was no unifying doctrine, let alone a philosophical underpinning. And courts, being what they are, more often than not sealed windowless boxes in which one might chance upon a jurisprudential Schrodinger's cat, nobody thought to look out at the rapidly changing world outside. The advent of the internet, the digitization of governance, the explosion of surveillance technologies, and the creation of Aadhaar brought privacy to the center of public life. The law has always been out of step with technology. This yields a persistent legal ambiguity, and it is in this dichotomous context that the challenge to Aadhaar brought privacy roaring back to the Supreme Court, this time with urgency and a call for long overdue clarity. From a timorous beginning, with courts hesitant to read into the Constitution a right not explicitly mentioned, to a gradual recognition, and then to a broader articulation under Articles 21, we see a sort of progression. This is best understood by seeing it graphically. From first conceiving privacy as a defense of a physical space, every person's home is her or his castle, to one that mushroomed to include information, autonomy, reputation, and above all, choice. The early cases were the building blocks on which the right to privacy was ultimately constructed. They showed that privacy was not a foreign transplant, but a deeply Indian concern. And so what began as a cautious, hesitant idea eventually crystallized into a constitutional doctrine. I need to say this evolution was not inevitable. It was the result of persistent advocacy, judicial reflection, and the demands of a changing society, it was also the product of a constitution that, though silent on privacy, has never been indifferent to dignity. Puttaswamy. The year is 2017. In a courtroom in New Delhi, 9 judges of the Supreme Court of India are sitting together to answer a question that has been raised and frequently deferred for 6 decades. Does the Indian Constitution guarantee its citizens a fundamental right to privacy? Consider the context. By the early 2010s, privacy had moved to the center of the national debate, largely due to the Aadhaar project. From the beginning, this was hugely controversial and driven entirely by technology with absolutely no regard for the law. Indeed, when first introduced, it had no governing law at all. The thinking was that if technology could ensure last mile welfare delivery, the law would simply fall into place. For who could possibly argue against the purpose of such shining purity? Biometric authentication for access to government services and benefits, the thinking went, overshadowed all other concerns. Aadhaar quickly became a central instrument of the state's digital infrastructure. But it also raised deep anxieties about surveillance, exclusion, profiling, and the centralization of personal data. When the Aadhaar scheme was challenged in court, the Union government initially argued that there was no fundamental right to privacy under the Indian Constitution at all. This argument rested on the old precedents of Khadak Singh and MP Sharma. But at the heart of the Aadhaar litigation was a deceptively simple foundational claim that every Indian citizen had a right to privacy, and this right constrained how the state could collect and use citizens' personal information. But there was a complication. In previous rulings, the Supreme Court had held that the Constitution did not explicitly guarantee a right to privacy, and at least one judgment was by 8 judges. These cases, though dated and sometimes cautiously qualified, had never been formally overruled. And so, before the court could decide whether Aadhaar violated the right to privacy, it had to answer a prior and deeper question, whether such a right existed at all. And when it did this, there was a unanimous affirmation that the right to privacy is not only fundamental, but central to the Indian Constitution. The Puttaswamy judgment is huge in its size, 637 pages, and in its reach. 6 of the 9 judges weighed in, coming at it from different angles, but all converging on one focal point, that privacy is inherent in human dignity and therefore intrinsic to the fundamental right to life and personal liberty under Article 21. I won't take more time describing how each judge has dealt with it. It's enough to note that the judgment was decisive, it was bold, and it expressly overruled MP Sharma and Khadak Singh to the extent that they denied that privacy was a fundamental right. It placed privacy, therefore, at the heart of a constitutional interpretation, not as a peripheral interest, but as a foundational principle that cuts across rights and remedies. It offered a clear and principled understanding of what privacy entailed. And to summarize this, it identified 3 broad dimensions. First, there is the bodily or physical privacy. Second, there is informational privacy, controlling the use and dissemination of our data. Third, there is decisional autonomy. But beyond that, Puttaswamy tied privacy to freedom and therefore anchored privacy with our fundamental rights. Now, there is a phrase that nobody in his or her right mind would use in daily conversation, and literally and visually it presents an absolute impossibility. But lawyers and judges simply adore saying that such and such a thing is both a shield and a sword. In human history, outside of the law, nobody has ever seen such a thing. But it rears its linguistically ugly head with depressing regularity, and Puttaswamy is no exception. This word shield appears at least 15 times, but fortunately, sword does not. But the twinning is repeatedly emphasized as privacy's positive and negative dimensions. The judgment said that the state's negative obligations restrain it from intruding into individual life without just cause. Any intrusion must pass constitutional muster. This is apparently the shield. On the flip side, the unspoken sword, the state's affirmative obligations require the state to create legal and institutional frameworks to protect citizens' privacy from non-state actors. This includes enacting data protection laws, regulating technology companies, and so forth. But the most forward-looking aspect of Puttaswamy was its acknowledgement of the challenges posed by the digital world around us today. It noted that in an age of smartphones, biometrics, cloud storage, and AI, privacy cannot be confined to physical spaces. It must evolve, that is, the right must evolve, to address new technologies, new forms of data collection, and new kinds of power. We must understand that Puttaswamy did not elevate privacy above all other considerations. It was a fundamental right, but not an absolute one. Interference with privacy is permitted, but this is only if three tests are satisfied, and all three must be satisfied. The action must have a basis in law. There must be necessity, the pursuit of a legitimate state aim. And three, the test of proportionality must be met. All three are required. Now, the Puttaswamy judgment became, I think, the constitutional foundation for the subsequent Aadhaar judgment. But it also provided the jurisprudential basis for decriminalizing homosexuality in Navteej Singh Johar versus Union of India in 2018, where there's a recognition of the right to intimacy and sexual identity. It has also shaped ongoing debates on data protection, facial recognition, and so on. But perhaps most importantly, it signaled a seismic political and constitutional shift from treating citizens as subjects, a thinking common to political parties of every stripe and persuasion, to recognizing them as autonomous individuals with inviolable, constitutionally guaranteed rights. The promises that Puttaswamy holds out will need to survive severe tests that lie ahead. But I think in its powerful framing, we do have the toolkit to meet those challenges. There are some areas that require mention. I'll ask you to bear with me for just a little while. This is important because of the rise of the surveillance economy. And there are three specific areas where privacy continues to be a major concern. We often discuss it in abstract universal terms. It belongs equally to all. But in reality, privacy is not equally available. It is shaped by power, access, identity, and inequality. It is experienced differently, sometimes denied altogether, by those who live at the margins of society. For privacy intersects with gender, sexuality, and caste, three powerful axes of marginalization in contemporary Indian society. For many women in India, the idea of privacy is not a legal abstraction. It is a daily struggle. It is the freedom to close a door, to make a call, to walk unaccompanied, to study or work without scrutiny, to refuse marriage or to leave a violent home. Basic freedoms for women are too often seen as threats to the social order. In Indian households, privacy for women is routinely denied in the name of protection. This is again power play. Their phones are monitored, their movements are controlled, their conversations are policed. In many cases, families act as surveillance units, enforcing hidebound and prelapsarian norms of chastity, obedience, and invisibility. Outside the home, the public realm is no safer. Urban planning rarely prioritizes the safety or autonomy of women in public places. A brilliant book, Why Loiter, examined the threats to women who choose not to hurry home from work, but to dawdle as their male counterparts are so wont to do. In rural areas, the denial of privacy is even more stark, especially in matters of sanitation and healthcare. This denial of privacy is not accidental. It is a mechanism of control and a way to reinforce patriarchal power and to restrict autonomy. Nowhere is the link between privacy and dignity more apparent than in the lives of LGBTQ plus individuals. For decades, consensual same-sex relationships in India were criminalized under Section 377 of the then IPC. This criminalization not only denied equality before the law, but also made privacy itself illegal, particularly the right to love, to form relationships, and to define one's own identity. In Johar, the Supreme Court struck down Section 377 partly to the extent that it penalized consensual acts between adults, and it did so relying heavily on Puttaswamy. But nobody remembered to tell that constable or that policeman in some distant district in Chhattisgarh that part of Section 377 had gone. The problems persist despite the recognition in Johar. And what is that recognition? That recognition is simultaneously moral, social, and constitutional. Intimacy is not a cause for shame. Difference is not deviance. LGBTQ plus persons are entitled to the full protection of the Constitution, including the right to privacy, dignity, and equal treatment. But it is confronted, this right, with ongoing pervasive and perverse social conduct, outing by family, employers, or media without consent, discrimination in housing, healthcare, and employment, including refusing judgeship, aggressive policing of relationships through harassment, threats, and violence. Where, I must ask, are the respectful and confidential medical services for queer and trans persons? The fully implemented protection from forced disclosure by employers, institutions, and media, and the systematic attempts to educate. By the way, I hate the word sensitize. The police, and yes, even the judiciary. And why have we turned our faces away from explicit affirmative legal recognition of same-sex relationships, family, and gender identities? Caste. is not just about hierarchies. It is simultaneously about power and about identity. Historically, for Dalits and other marginalized castes and classes, some form or the other of social surveillance has always existed. Where they live, with whom they associate, how they dress, whether they access common resources, all of these are monitored, regulated, and when challenged, visited with violence. Worse, this control begins early at institutional levels. From school registered to job applications, from ration cards to government databases, caste is recorded, indexed, and circulated. While this serves the important purpose of affirmative action, it also carries the risk of stigmatization and the breach of dignity. When digital databases link biometric data with caste and socio-economic profiles, as in some rural employment schemes or scholarship programs, privacy concerns become acute and usually problematic. To be sure, caste-based data can empower, but it can also exclude and thereby reinforce the very inequalities it seeks to address. Should privacy frameworks be caste blind? Would that serve justice? How do we mitigate the risk of digital data being used against marginalized castes? How do we ensure that the collection of digital data that includes caste, especially among the poorest, does not feed into a continuance of living everyday vulnerabilities? Puttaswamy began a conversation, one that is, I think, still unfinished but is deeply consequential. Digital systems such as Aadhaar link database are increasingly used to verify identity, prevent fraud, and deliver subsidies. But what happens when the system fails? Take the example of welfare exclusions due to biometric mismatch. When fingerprints fail, they often do, individuals are denied rations, pensions, or wages. This has become a huge problem across at least 4 or 5 of our states today. It is being attributed to technical glitches. But it is far worse than that. It is a full-scale betrayal of a constitutional guarantee and an absurdly devious denial of the very purpose for which Aadhaar was established. For now, far from delivering benefit, it now serves to deliver the most terrible punishment. Imagine not being able to access your own bank account into which flows a government subsidy or a pension only because a government-driven Aadhaar system claims that there is a mismatch. For me, and this is the science fiction part of it, the most profound lesson in Puttaswamy is its recognition that the Constitution is for you, spans both time and space. It moves into areas unforeseen as new challenges arise, and it unfolds in time much as our universe does. Privacy is but the latest of these space-time expansions. This is possible only because of the recognition in judgments like this one of our fundamental constitutional principles. It recognizes the precepts from our preamble, which continue to rumble: justice, liberty, equality, and fraternity. And it is in the crevices or interstices between these that we have now successfully positioned privacy. Two turbulent rivers collide here: democracy and data. In that confluence, remembering that the Constitution is not history, but a constant blueprint for the future, it falls to us to find how best to navigate these waters such that privacy in everyday life is protected and respected. If the Constitution is our compass, it is also a tolling bell. How do we gauge ourselves? How will future generations judge us? It will not be enough, I suggest, to be remembered for allowing tyrannical, all points control by state level players. Even good governance, which has all but collapsed today, will not suffice. The true test, I would argue, would be to gauge the flow of trust between the state and the citizen. For a state that distrusts its own citizens is a failed state. And in this digital era, that trust must be earned by an explicit recognition of privacy as a fundamental right not in law books but in actual daily practice. The power structure needs to be set right. Those who collect data are not to be our masters, they are to be the servants of we the people. As we move into an increasingly digitized and interconnected world, we must ask ourselves, what kind of society do we wish to become? One that watches, snoops, spies, surveils, and controls, or one that trusts and empowers and actually governs? The answer to this will shape the future not just of law, but of our democracy itself. Thank you for listening.